the first to know Nsem-Pii TV.
Dominic Akrutinga Ayine, Attorney General, or serve as the Minister for Justice. Now, after the appointment, in fact, with two and Amobia, it is not going down well with so many well-meaning Ghanaians. Kwanya Ofaswa, high-profile cases. They say, "What training name? Why not you say only a chilkra?" One of the high-profile cases, the $200 million Sagleme housing scandal. Yenim Alhaji Collins Dauda, Alhaji Jacob Ziblim, Afi Angelo Klokana. Yamefa the currency now where Jumadema Constructura OAS, the company that was responsible for the construction of some 5,000 housing units. It was Sagleme. $200 million in Nasa. Housing units 5,000 no yentumi ensia manandru. According to forensic audit by the Ministry of Works and Housing, emu 883 ena na ye completed. Out of that 883, none of them ena na ye habitable. $200 million eshi. Ye twini kwajina mrenim for intentionally misapplying public funds and other 69 charges. Dominic Ayine si wetwam. 2.37 million euro ambulance scandal. Dr. Casey Lato Forsen, Richie Japa, Sylvester Enimana. The government of Ghana contacted Omonko procure ambulances from Big C General Trading Limited in Dubai and family women. Ambulance ne bedru omayimuno. The former health minister under the S.Y. Muhammad administration, Alex Segbefia, ne krata ujato was hand over note to the Adansi say those vehicles were not fit for purpose to serve as ambulances. Hence, Omaina Boka, ena ye kasei, Karwa ne tuti se tea bread no, SCC 37 military hospital. Enwa, yentumi amfa nye jumabia. Enonswa, it could not be converted into ambulance. Yetweni jina mrenimu for causing financial loss to the state. Dr. Dominic Ayine si, mechob. Stephen Kwabonopuni, 271 million Ghana cedis could purchase a little bit fertilizer. Ya na ni efficacy ewo form ahamwayen yetwini ko gina mranim Dr. Dominic Ayine ba ya wase matwam Samuel Ofoswampofo Kwaku Boahen were heard on tape ya omo kansem yebema amana yon governable yebehyishi dwa yebeyese eventually some omo kan wo tape no mu nyina started occurring tape yi yese yomoni yese nyomoni yede ko Israel. Through forensic audit, it was determined that truly the voices Samuel Ofoswampofo and Kwaku Boahen. Yet you be jina mrenim Dr. Dominic Ayine say men to aso bio metwam. Senate OBS scandal. Obi de say yura Ernest Thompson and 5 others so mo koto software e dia ba be boa ma Senate dwumadie akoso. Some $66 million went down the drain. Software na anya dwuma da e de besinne yetwa mo ko jina mrenim Dr. Dominic Ayine si metwam. Na entwamu ni nyina no ya reasons awodeba entasumu no enane former attorney general the Leonard Godfrey Yebo Adame press conference na press conference no chechirinsimu na wo kiremu a enne ya wo kasei the General Legal Counsel Asemon Dr. Dominic Ayine two former chief justices of this country. And almost as I said, Nyoma Dr. Dominic Ayine ye wo man ni mu omo ntiase into amaro mechichirim. The other series of revelations, the Leonard Godfrey Yebo Adame ya say I expose Dr. Dominic Ayine kra reasons awodema for discontinuation of all these cases, it doesn't hold water and it is not going to stand the test of time. And it is straight away besi ye move ni ko ni ekotie lawyer Di Penyiripa ya Osanbeye Minister for Justice and Attorney General Lawyer Godfrey Yebo Adame the live press conference oye setting the record straight proving that Dr. Dominic Ayine oni Ghana for any year.
In the face of this clear judicial pronouncement of no wrongdoing as to warrant a mistrial, it completely defies logic and good reason why the Honorable Attorney of Ghana will say to the public that I was culpable of what he describes as a disgraceful and unethical conduct in the ambulance trial. Ghanaians want to know rather how the current Attorney General, Dr. Dominic Ayine, will deal with the complaint of professional misconduct pending at General Legal Council against him, but no less a person than the former Chief Justice of the Republic. Ladies and gentlemen, in a chilling twist, the nation heard Dr. Ayine confessing to speaking with lawyers for the defense and engaging them on the cases that were pending against leading members of the NDC before exercising his discretion to file no prosecution or withdraw the charges. He indicated that in Republic versus Jachikwesen, the lawyer for the accused expressed an inclination to go on and prove the innocence of his client, and therefore he decided not to enter no prosecution. Respectfully, what this betrays clearly is that the exercise of Dr. Ayine's discretion to continue the prosecution of cases or not is informed principally by the disposition of counsel for the accused in cases that the Republic is prosecuting against their clients. Thus, if counsel for the accused is in a position to strongly defend the interests of his client in court, the Attorney General of the Republic will not enter no prosecution. Where the counsel for the accused are not convinced about the likelihood of a success of their defense in court, Dr. Ayine would immediately enter a no prosecution if the prosecution has not closed his case, and a withdrawal if the prosecution has closed his case, so that an acquittal and discharge will be secured. As I will show in an examination of each of the specific cases cited in Ayine's press statement, the Honorable Attorney General quite reprehensibly relied solely on the case for the defense before exercising his discretion to discontinue the actions. He did not engage in any meaningful consultation with the prosecution's division of the Office of the Attorney General before instructing the filing of the withdrawals and no prosecution in the cases against senior members of the John Mahama government and other leading members of the NDC. The dates of filing of the said processes buttress the assertion I make, and I've referred to them already. I challenge Dr. Ayine to show any memorandum presented to him by the prosecution's division of the Office of the Attorney General advising or indeed expressing a view on the consultation, discontinuation, or termination, as he calls it, of any of the criminal cases in question. I can say without any fear of contradiction that there is none. He should also show evidence of consultations on any of the charges he held with the Director of Public Prosecutions, the DPP, before discontinuing the cases. You can be assured he cannot produce any. Listening to Dr. Ayine, one gets a distinct and chilling confirmation that he relied solely on the version of the facts as presented by counsel for the accused, as well as their erroneous views of the law on the subject matters in question. It is for this reason that the claims of alleged defects in the various charges only re-echo positions articulated by the defense counsel throughout the various proceedings. In effect, Dr. Ayine came to narrate to the Ghanaian public on Wednesday the perspective of defense counsel on the charges their clients had been charged with. The media would notice that for each of the cases, the explanations of the Attorney General for the withdrawal were only a rehash of arguments already reported in the media as having been made in the courtroom by counsel for the defense. Is that a reasonable manner of the exercise of the Attorney General's discretion to enter no prosecution and withdrawal of criminal cases? I ask. The people of Ghana should be very scared if we have an Attorney General whose prime consideration for the discontinuation of criminal cases involving the loss of billions of Ghana cedis is the position of defense lawyers on charges preferred against their clients rather than the interests of the Republic in the prosecution of crime. Even more scary and bizarre is the claim of Dr. Ayine that he did not consult the former president, John Dramani Mahama, before taking the monumental decisions to discontinue the criminal cases. The cases involved the loss of colossal sums of taxpayers' money and some related to the banking sector crisis which affected the Ghanaian economy. The people of Ghana should indeed be extremely concerned and afraid by the vesting of prosecutorial authority in a person who can discontinue the prosecution of such important and high-profile cases without discussing with the President of the Republic and members of the Cabinet. Even defense counsel, according to him, he consulted. How much more the President? But ladies and gentlemen, we ought to ask ourselves, is it true that Dr. Ayine did not consult the President or his Cabinet about the decision to discontinue the various criminal proceedings? A careful examination of the facts shows that this claim is palpably untrue. The nation has not forgotten the loud claim by President John Mahama and the NDC that the MPP rather was responsible for a collapse in the banking sector crisis. And that on assuming power, the John Mahama government will restore all the banking licenses which were revoked. The withdrawal of the cases in question is only the first step of the clearing or whitewashing process of those whose acts led to the crisis that plagued the banking sector. Ghanaians are certainly more discerning than the NDC and Dr. Ayine think. I proceed to examine Dr. Ayine's reasons for withdrawing some of the criminal cases Dr. Ayine mentioned in his press statement. And I find generally that all his explanations are laden with contradictions and inconsistencies and betray the questionable motives for his actions. First is the Republic versus Kesea Tuforsin and another case. The first reason assigned by the Attorney General for the discontinuance of the appeal is ethical and professional, since, according to him, he was deeply involved in the conduct of his defense, that's the defense of Dr. Tuforsin. He could not, according to him, in all good conscience, continue the conduct of the appeal. This explanation is a sham, as the Attorney General's prosecutorial authority under Article 88, Clause 4 of the Constitution is exercised by himself or, in a quote, any other person authorized by him in accordance with any law. Pursuant to this, the Criminal and Other Offences Procedure Act 1960 Act 30 permits attorneys of the Office of Attorney General and other persons, including even private legal practitioners, to whom the Attorney General may delegate his powers through an executive instrument enacted pursuant to Act 30 to prosecute. Thus, the fact that he, Dr. Ayine, found himself in a conflict of interest situation did not imply that the entire appeal had to be abandoned. Dr. Ayine characterizes the prosecution of the ambulance case as a political witch hunt. I wholly disagree. The facts show that vehicles purporting to be ambulances were imported into the country in December 2014 in violation of the contract governing the transaction. In the absence of any request by the Ministry of Health, and at a time that the period for supply of the ambulances and the contract had even lapsed, Dr. Kesea Tuforsin, by letters dated 7th and 14th August 2014, instructed the Bank of Ghana and the Controller Accountant General to issue letters of credit, which was the agreed means of payment for the vehicles under the agreement. The letters of credit were consequently established on 18th August 2014. Big C General Trading Limited, the suppliers to the vehicles based in Dubai, whose contract had no parliamentary approval, proceeded to ship the vehicles on receipt of the letters of credit. When the vehicles arrived, they were not of the kind specified in the contract and had serious defects with every material part of the vehicles, which rendered them unfit to be described as ambulances. Indeed, a John Mahama appointed Minister for Health at the time, Dr. Nsem-Pii, described the vehicles as ordinary vans, not fit for purpose. The defects were so irremediable that from the time the vehicles started arriving in December 2014 to January 2017, when the SR John Mahama administration left office, they could not be converted into ambulances. To date, they cannot be converted into ambulances, and John Mahama government is back in power. I am of the honest view that the split 2-1 decision of the Court of Appeal, far from confirming Dr. Ayine's position that the case was flawed, was erroneous, and the Republic's chances of having same set aside by the Supreme Court was very high. If Dr. Ayine was convinced that his position would prevail on appeal, why did he not allow the appeal to run its course for a vindication of his views? What did he or his former client, Dr. Tuforsin, stand to lose by the termination of the appeal by the Supreme Court? Ladies and gentlemen, I observe that the real reason for his continuance of the appeal by Dr. Ayine was that he did not wish to deepen the woes of Dr. Tuforsin any further. Republic versus Ofusuampofo and another. Dr. Ayine did not advance any reason whatsoever for the withdrawal of this matter, save that he was on record as counsel for the defense. I have already pointed out above the absurdity of such a position, and I will not recount. The self-serving nature of Dr. Ayine's decision is too apparent for the people of Ghana to see. Republic versus Collins, Dowda, and 5 and 4 others. The reason advanced by the Attorney General for the entry of nolle prosequi in the case filed against Mr. Collins Dowda and 4 others for their roles in the Sagleme housing scheme is that, in his view, the charges were defective. He claimed that the prosecution wrongly charged the former Minister Collins Dowda with the offense of misapplying public property, i.e. funds, in the sum of 200 million United States dollars. In Dr. Ayine's view, the prosecution should have taken into account the fact that part of the $200 million was used to construct the houses at Sagleme. With the greatest respect, this analysis by Dr. Ayine portrays a complete misapprehension of the ingredients of the offense of misapplying public funds. The offense of intentionally misapplying public property consists in wrongly applying public property, which is defined under the Public Property Protection Act of 1977, SMC Decree 140, for a purpose other than as lawfully approved. It is different from the offense of willfully causing financial loss to the state, whose defining ingredient is the actual loss occasioned the state through one's willful act. In this case, Mr. Collins Dowda was charged with the offense because he intentionally misapplied a sum of $200 million for the construction of 1,412 housing units instead of 5,000 housing units lawfully approved by a cabinet, the Parliament of Ghana, and the Public Procurement Authority to be constructed. To the question of how much was disbursed by the state during Collins Dowda's tenure as Minister for Western Housing, or the exact amount spent on the buildings when he was minister, is immaterial. The real question is whether Collins Dowda authorized the application of the sum of $200 million for the purpose lawfully approved for the project, i.e. the construction of 5,000 housing units. The answer to this question can only be in the negative. I say that in any event, if the Attorney General also the considered view that the sum of $200 million mentioned under the count of misapplying public property should have been $94 million, all he had to do as a good prosecutor, acting in good faith, was to amend the count. The remedy is not a discontinuation of the entire case, especially when that offense of misapplying public property constituted only one out of 70 charges filed in the case. What happens to the other 69 charges that Dr. Ayine does not fault and did not talk about? With the greatest respect, the state should be seriously worried if her Attorney General demonstrates such ignorance of the basic principles of criminal law and the ingredients of offense, which border on the protection of state funds or public property. The second factor cited by Dr. Ayine for the withdrawal of the Sagleme case is the alleged failure of the prosecution to charge other ministers who took office after Collins Dowda left office. This is another palpable falsehood. The state charged all those whose roles in the criminal liability. This included Kweku Adjumah-Mensah, who signed and authorized the payment of money and who was John Mahama's Minister for Western Housing after Collins Dowda left office until January 2017. It also included a Chief Director, Alhaji Ziblim, who was in office until 2017, covering a part of the tenure of Mr. Atachia as minister, and signed and authorized payment of money. Dr. Ayine raises issue with the failure to join Honorable Samuel Atachia as an accused person in the matter. It ought to be made clear that the prosecution of crime is not an arena to achieve political equalization. A careful check of the fact would have disclosed to Dr. Ayine that Honorable Samuel Atachia never authorized any payment for the Sagleme project. Mr. Atachia was rather the one who called attention to the bizarre circumstances of the project and wrote a letter seeking the advice of the then Attorney General, Ms. Gloria Efua-Akufu, in or about 2019 for an urgent termination of the contract, a decision which stopped the state from unnecessary financial hemorrhage. The sum of $5 million that Dr. Ayine alludes to was authorized to be paid by the then Chief Director, Mr. Solomon Asola, and not Mr. Atachia. The decision by the prosecuting team not to charge Mr. Solomon Asola, but rather to use him as a prosecution witness, was because an examination of the record showed that Mr. Asola, in truth, tried to save the Sagleme housing project from total collapse. The sum of $5 million was authorized by Mr. Sola to be utilized for the project to save the project. Further, he assisted in shedding light on the relevant facts of the project. Hence, the prosecution's decision to use him as a prosecution witness. Prosecution of Dr. Johnson Pandit Isiama. The narration given by the attorney general about why he is continuing the two different cases against Mr. Johnson Pandit Isiama again disclosed a litany of untruths, half-truths, and a skillful manipulation of the fact. Be that as it may, as it is with any manipulation of fact, the truth is always laid bare or being subjected to careful analysis. The first case involving Mr. Dr. Johnson Isiama Pandit, or Dr. Johnson Pandit Isiama, is the Republic versus Kwabena Dufo and others, the Union Bank case. This case involved an approval by Dr. Johnson Isiama of the sum of 450 million Ghana cedis for the benefit of Universal Merchant Bank, UMB. Part of that sum was 300 million Ghana cedis, which was an unsecured facility approved by Mr. Johnson Pandit Isiama for UMB for the benefit of Union Bank Ghana Limited. The sum of 300 million cedis formed the basis of a charge of making approval in contravention of the Bank of Ghana law. The remaining amount of 150 million Ghana cedis formed the basis for the offense of willfully causing financial loss to the state. It is necessary to state that contrary to Dr. Ayine's claim, the sum of 150 million Ghana cedis to date remains unrecovered. I must indicate that I find the line of thinking of Dr. Ayine that simply because an alleged loss to the state is recoverable after the offense has been committed or the charge filed, the offense of willfully causing financial loss is rendered invalid, very strange and insupportable in law. Also, an amount paid in violation of the law, when subsequently recovered, does not clear the person who gave the approval to be made of wrongdoing in the first place. The anchor of Dr. Ayine's explanation for discontinuing the case against Johnson Pandit Isiama is a memorandum allegedly delivered to my good self by attorneys of the Office of the Attorney General, reportedly, as Dr. Ayine stated, and I quote him, recommending that the charges against him be dropped. End of quote. Let me state for the record that, to the best of my knowledge, no such memorandum exists.